we debated this, we talked about this earlier today, prosecutors have to be sharp, judges have to be sharp. Let's explain to our audience when a judge fails to charge a lesser charge, specifically, what does that mean and why did that lead to the reversal?
So when the judge and the parties get together to discuss what the ultimate charges that go to the jury are going to be, each side is going to submit the proposed charges that they're looking for, and it's ultimately going to be the judge's decision. But there are certain areas that the judge is kind of required to make sure that they follow the procedural rules, and one of those is lesser included. And what a lesser included charge is, for those of you who don't practice criminal law, is it is something that that is kind of getting to the actual charged crime, but has a lower kind of burden. So the easiest way to think of this is if there are 5 elements to the charged crime that the prosecutor has to prove, each one of them beyond a reasonable doubt. If there's a lesser included that has 3 of those 5 elements, but you only need 3, you don't need 4 and 5, that would be a lesser included, so that you could find the prosecutor proved 1, 2, and 3, and therefore hit the lesser included, but did not hit 4 and 5, so they didn't hit the charged crime. So for a crime like malice murder, something like involuntary manslaughter would usually be a necessary lesser included charge. The death took place, but there's no necessarily intent to actually have caused the death. So the failure to charge a lesser included and give the jury that option to say, well, I believe, enough of the elements were hit for the lesser included, but not for the charged crime, is reversible error. And so that's what happened here. The judge did not include the lesser included to the jury as an option, and therefore the appellate court came back and said, that's reversible error. You needed to have that.
Now, Aaron, that was a perfect description of what a lesser included is and what the court did. And it has very real practical implications in the courtroom, especially as it relates to sentencing. And there are a lot of times game playing goes on amongst the lawyers because the judge will say, well, what charges do you want? And what charges do you think are appropriate? And sometimes prosecutors, in my opinion, make a mistake and ask the court not to charge a lesser included offense, thereby giving the jury the draconian choice of either an outright acquittal or a not guilty or a conviction to the higher charge. And the idea here is that you box the jury in from finding, based on the facts of that case, something that wasn't the lowest, wasn't the highest, but was somewhere in between. And the failure to have done that prejudiced the defendant. And in truth, Aaron, that is true. Jurors sometimes will have to make that draconian choice, but say, I wish I had something in the middle. What are your thoughts?
That's absolutely true. And it does happen in cases of all types, not just murder. There's lesser included of sexual crimes and things of that nature where we see this. And a judge has to weigh and balance the evidence that's come out. In the state of Arizona, a lot of other states, the judge can put a lesser included on even without the two parties agreeing to it. So that could be something that happens as well, so that you avoid that box in type of situation.
No, you're exactly correct. Ultimately, it's a judge's decision as to ultimately what they're going to charge. So once again, we have to retry a case, which doesn't do anybody any favors. Guys, great job. Really appreciate it. That's it for me. Stay tuned for our regularly scheduled program. I'll see you next week.